recording today. So if you know of somebody that missed being with us and would love to hear what we talked about, they can join us. So good morning and welcome to this would be our third in our Shift, Sustain, and Succeed series. We welcome everyone to join us every Tuesday and Thursday as we do our best to find answers to the most pressing questions that our businesses have in navigating the COVID-19 situation. Last week, we talked a lot about EIDL and PPP loans and the issues around funding. We'll keep talking about those, I'm sure. But today, we're going to move on and we're going to focus on some of the human resources issues and how employers can navigate these sometimes muddy waters. Very qualified to assist us are our guest today, Pam Watkins, who is the Director of Human Resources for Matric Group, one of our region's largest employers. And probably most of the people on the call know Pam. She has a lot of experience in our region, so it's great to have a familiar face working with us today. And attorney Mark Kuhar of Knox, McLaughlin, Gornall, and Sennett in Erie. And Mark has worked with some of our local school districts and has clients here in Venango County. So while I'm seeing him for the first time face-to-face, he's very familiar with many people in our community. So I thank you, Mark, for joining us. Mark specializes in employment and labor law. So I'll remind everyone that the rules keep changing. Some of them haven't even been written. So Pam and Mark will provide us with insight based on what they know today. And that will hopefully help us work within the law while respectfully taking care of our business communities and our greatest assets, our employees. We will be recording today's session as we have previous sessions. If you have additional questions that develop as we go on, please put them in the Zoom chat and we'll do our best to answer them towards the end of the call or to do some follow-up. So with that, we'll go ahead and get started. Mark, we're going to start with you. So we're all hearing about the FFCRA leave. Can you tell us a little more about what that is and how that impacts our employers?
Sure. The FFCRA leave is Families First Corona Relief Act, and that was the first of the series of federal legislative efforts to assist with this whole situation, and it was effective April 1st, so a lot of employers are familiar with that. They had an obligation to post notice about the leaves available under the FFCRA beginning April 1st, so if that hasn't been satisfied, that would be a good and easy thing to do. FFCRA leave is basically comprised of two different types of leave. One is called emergency paid leave, which can only last 2 weeks, and it's separate from FMLA leave. Then the other type of FFCRA leave is called Expanded Family Medical Leave Act leave, which applies to all employers with fewer than 500 employees. So even employers who are listening to this, probably many employers who are listening, thinking, hey, I'm not an FMLA employer generally, and you still are not generally, but for calendar year 2020, you are, if you have any employees, you are subject to the, quote, Expanded Family Medical Leave Act benefits. And real quickly, the sources for more information on that would be the poster. So if one were to just Google USDOL FFCRA poster, they would get a quick summary of the different types of leaves and who can qualify. And then there's 70 FAQs which are answered. Also, again, you could Google that, USDOL FFCRA FAQs. And then if you really want a more detailed answer or just really want to go deep in the subject, the DOL has 150 pages of regulations that are called interim regulations, all dealing with FFCRA.
Great, good overview. Pam, is there anything at that point that you'd like to add to?
No, I think he covered it, and there's tons of information about it, and there's also some very helpful flow charts for HR professionals and business managers that are trying to determine where to put them, okay, if you have a situation. So good flow charts are available online as well.
Great. And Pam, I will ask you here, are you experiencing employees who are asking for leave at this point?
Absolutely, we have since the beginning. I would say that the larger majority of it has been for childcare, and that's where we're seeing the lion's share of it.
Okay. And in fact, I have a little note here to ask about childcare and how that impacts. So one of the things we would expect may happen is employers will start to call people back because they're maybe as they transition into yellow, but they still don't have childcare. School hasn't started. The daycare centers are beginning to open up, so some may have it. Can either of you speak a little bit to how the childcare issue relates as we go into the extended time and into summer?
Well, the FFCRA leave is applicable for situations where someone is the primary caregiver for minor children whose daycare or school has closed. For school children, their schools are closed. Of course, that it's going to be interesting to see whether when the school year ends early June, mid-June, when those school year ends, it's going to be interesting to see if we have any issues arising out of basically the potential to say, hey, in past years, you came up with some kind of solution over the summer. You probably should try to find that same solution now because your use of the Expanded Family Medical Leave Act under FFCRA was clearly appropriate during the school year, but now that we're not in the school year, why do you need leave when you didn't in prior summers, for example? And I don't mean to sound edgy, but that's the kind of issue that could arise. Real quickly, I should emphasize that the payments made under either type of FFCRA leave are reimbursable to the employer pursuant to a tax credit. So for example, in the second quarter, if you pay out these leaves, as Pam described doing, her firm will take a credit on the tax withholdings that it sends into the government, probably in July. And I also want to quickly mention that I think there's actually an opportunity there. We obviously myself and the chamber encourage complete compliance with all the rules and regulations. But I do think there are situations where an employer could actually present the issue to an employee, particularly a slow employer, and say to an employee, this benefit is available to you, and if the circumstances warrant it, the person might say, oh, I didn't know you were open to that. Oh, heck yeah, we're very open to that. And in fact, then the employee leaves, their pay is continued or partial pay is continued, as the case may be, under the FFCRA, and then the employer ends up getting a credit for that in situations where otherwise the employee might either be, maybe underutilized and or a cost to the organization. So food for thought. I don't think people are using it quite as aggressively perhaps as they could. And by that, I mean employers as well as employees.
Right. Mark, that's a great point. I think this is a time to be really strategic, to talk to the other professionals in your life, whether it's your attorney, your accountant, your HR professional. I know a lot of small businesses don't have those people, but this is a time that you might think about how that would benefit you and take in things like this and be strategic with the money as it's coming in. Thank you for adding that. Pam, one thing we're hearing is that as businesses are beginning to be able to call people back to work, and maybe some have already experienced this, they have an employee who is really afraid. They have a fear of getting COVID-19. They're hesitant to come back to work. Can you talk about where that sits with the law and good practice?
Sure. So I'm sure many people have experienced it. I've had multiple calls about it. So basically the act, as sound as it is at this point, it doesn't cover fear. But employers should really take time to weigh out the employee's legal rights and concerns with practical business needs. So I always believe in communicating very openly and very frequently with employee base. So it's a lot of listening and empathizing. And if your company has taken steps, measures to protect your workforce, you should talk to them about that. They should be able to see it. Are there Clorox cleanup wipes on all the workstations? Do you have barriers? Are you wearing masks? Are you doing temperature checks at the doors? And talk to them and review kind of what your company's done proactively to make sure that they are protected. If somebody is really still uncomfortable and they don't qualify under the act, right? then you can offer up letting them take some of their paid time, vacation leave, or take it unpaid if they're not critical. A couple of things just to do research on. The OSHA Act, okay, does cover and protect employees who refuse work because they believe there's an active, a real threat of serious harm or death. Now, what does that look like? Well, for example, if I told an employee that they have to get on a plane and travel to China, and good luck with all that, and we're not providing you any PPE, okay, that would be problematic at this point in time. But to come into a workplace that has been doing all of the right things and that you've not had any active cases, right? It's not the same level of threat. So, you know, if you have an employee that has a medical condition, you might want to look at what can you do to help them. For example, if you have an employee that's has cancer and they're going for chemo and their immune system is weakened, can they work from home? Is there anything you can give them to do? Okay. And then, of course, under the ADA, you need to kind of look and see if there's an accommodation that needs to be delved into a little bit. You still have a right to ask for a form to be completed, but remember to do that interactive process. Help me understand why you need to have an accommodation. Can this accommodation be medically documented, and so forth. But I think you really look at your work environment first and see where you can reduce any contact. We expanded break rooms, for example. We took literally a large training room, made a second break room. You can stagger shifts, you can stagger lunch breaks, anything you can do to promote that social distancing and barrier. So I think that gives employees hopefully a little bit more confidence that their employer is doing the right thing to get everybody back and engaged.
Great, thank you. So my next question is, are my employees eligible for unemployment? And that kind of has some nuances to it. One is if you didn't actually lay them off, do they have a way of applying for unemployment? You know, what qualifies them? And of course, right now we know that unemployment is paying quite well. So a lot of people are quite attracted to that. Can either of you talk a little bit about what unemployment looks like for our employers right now?
Sure. And as Pam indicated, just as fear of contracting the illness in and of itself is not a covered reason to be absent under the FFCRA leave, it's also in and of itself not a basis to leave employment or refuse to come back to employment and receive unemployment benefits. There are a number of variations or fact scenarios, I should say, to this basic question that can result in different answers. For example, if the employee's health is demonstrably compromised, or if the employer were not complying with the requirements of the various orders, you know, didn't provide PPE, didn't provide barriers for retail sales clerks and things like that. And under some situations, possibly this is still pretty much a work in process, but if a person himself or herself is perfectly healthy but is living with a loved one who is compromised, what will UC do with that? That is yet to be determined. It's unclear. In all situations, though, where an employee refuses to come to work and attempts to or desires to receive unemployment for that, they should be found ineligible unless they have talked to their employer about that first, especially with respect to, you know, the absence of barriers or PPE or things like that. Under those circumstances, so employees, they sort of owe it to the system, they owe it to their employers to have that conversation first. I also want to bookmark, though, very prominently that employers' incentive for managing down their exposure to unwarranted unemployment claims is not what it was prior to March 27th. So Act 68, you could Google PA unemployment, relief from charges, COVID, you know, those types of things, and quickly find it, or go to the General Assembly's website, or it's probably, frankly, a resource on the Chamber's site. I'm not positive of that, but probably it is. In any event, you can find your way to the law that was effective March 27th that said if it's COVID related, and of course the key is, does the UC system pick up on its COVID related attribute? But if it's COVID related, employers aren't charged for that anyway. So you would be working hard sort of for the benefit of the unemployment pool, but not for your own tax rate, to the extent that you would scrutinize or challenge those claims or go to referee hearings to fight those kinds of claims. And then just one little adder to Pam's excellent answer to the last question would be something that I have recently been doing a lot of with employers, is in addition to what Pam was describing very well, is also to say what we're going to do when we get if we get a positive test. This will be the sequence that we will follow. And again, I don't even know whether Pam has had positive tests, but I've had 3 different employers in the last 4 days who have had positive tests, and walking the employees in advance through what's going to happen seems to be having a very calming effect when it does happen. So I'll just throw that out there. And if people are unsure about what that's actually going to be like, it is a little more difficult in counties that don't have departments of health, which is all of them between Erie and West Virginia, except for Allegheny County. There are only 9 county departments of health in all of Pennsylvania, and none in this region. So that's something that I have been advising employers about a lot. If somebody were interested in talking about that, what's that experience actually like for employers? Do they shut you down? Do you need special cleaning solutions? How long does the virus stay viral, which is actually the appropriate measure, not how long can one bug live, but how long is it viral? Anyway, a little bit of an over answer and a little bit of reaching back for that one, but.
No, that's great. I think from the Chamber's perspective, we've tried to stay one step ahead of everything to the best of our ability. And I think that's a great point that we'd be happy to try to help with, but I would encourage our listeners to be thinking about the what ifs and be prepared. I think that's fabulous advice. And the good news is there are a lot of people out there who have prepared. So in Chamber terms, we rip off and repeat all the time legally. I give permission to, take things that we have developed and share. So if there are members who need help with that, we certainly can look for, great templates for how small businesses can navigate their way through that. And just one other quick thing on unemployment. I know a lot of things are changing. They're a little different than normal, but the one thing I don't think that has changed is that to qualify for unemployment, you must be available and able to work. So if you are not wanting to or not asked to work for your current employer, to be eligible for unemployment, you still have to be in that status. Is that true, Mark?
That's a great aspect to the analysis. Yes, it's definitely still true that the state law Act 68 Senate Bill 68 that I was referring to earlier specifically says the eligibility criteria for unemployment have not changed. And that is something that I have been sort of watching, and frankly, I'm hungry for more data on what the UC is going to do with that, because the UC system could say, well, they're perfectly eligible, able and available for work, as long as it doesn't require them to leave their house. Well, that would not have sufficed a year ago. Will that now or not? I don't know. And in fact, recently, in your region, I had one where the employee said, I can no longer work in this retail position because of the vulnerability of my spouse. To which we said, fine, then why don't you start doing custodial work in the back room? Which kind of revealed that their primary reason for wanting to cease work was to get unemployment, because they were in that case, it was not too sincere, and not casting aspersions on anyone, but you can kind of flush that out sometimes.
Sure. I think one of the things that's happening for both employees and employers is they're dealing with unemployment for the first time ever. Mm-hmm. So a lot of people have never gone through the process. So then to be doing that now, when there is that little bonus attached, is can actually be quite attractive to some people to do. So
I'm sorry, and at the risk of maybe pushing past the limit on the time, I don't know how many employers picked up on the fact that all employers, forever, meaning not just associated with the COVID, but as a standing requirement going forward, all employers in PA have to give, quote, separated employees a notice regarding their opportunity to apply for unemployment and some other things related to unemployment that we never had to do before. That was slipped in as part of the state's unemployment bill that I've referenced a few times. I'm not sure how widely that's being discussed, but
yeah, that's a
it
good
is a
point.
requirement.
And maybe we'll want to follow up with something on our website referencing that, because I know I've said that to others who there was confusion, especially around PPP reimbursement, where employers were calling back people that they had perhaps laid off even before COVID, now need them back to get them on payroll. And I said, as a matter of practice, it should all be in writing. You know, when you are laying someone off, it should be in writing. And when you get laid off, you should ask for it in writing. Probably good measures.
From the HR side of the desk right now, what many of us are seeing is that if you have somebody that you want to call back and they don't respond to you, like you call them. So my recommendation is obviously reach out via phone, reach out via email, but then send it to them in a formal letter in writing and make sure you detail all the aspects of the job. And you have to give them some time to respond. You need to, if I do it, I send it certified mail to make sure that it was received. But once you have given them a time to consider that, and you put that in writing and you hear nothing back, then you can file a form called UC 1921. It's an employer questionnaire, refusal of suitable work, but you need all the details to file that form. It's a quick one-page form. But it's basically, you have to show that you've done your due diligence in trying to call that person back into equal employment, like same pay rate, same hours, same type of work, and that kind of thing. So that form is available, but again, put it in writing if you can.
Great.
Oh,
And
I'm sorry, but I have to emphasize this. What Pam said is absolutely right on. And even more so right on because of advice that was issued by the IRS on Sunday, which said that if employees refuse to come back, it does not hurt your forgivability on your PPP loan. So that's really breaking news, but only if you have offered it to them, the offer to return in writing, guaranteed same pay and benefits, and a few other things. So excellent point for a couple of reasons.
great. And so as I read that last night, Mark, the employer isn't held responsible for it, but the employee is not eligible for unemployment going forward. So it's important for the employer to document that, get that form in.
Agreed.
True. Great. I think that actually covers the next question that I think we've answered it, but I furloughed my employees. Now I'm ready to reopen, either because of going to yellow or I received my PPP loan and need forgiveness. I need them back on payroll. So I think we kind of addressed that with that last. And if any of the listeners feel that we didn't and want to put anything in the chat, feel free to, just submit questions or more clarification. So Pam, we did talk about preparing your space. You did a good job of talking to us about that. PPE, masks, face coverings in the workplace, clean spaces. What do we need to know about making sure we have OSHA compliant workspace?
So, well, if you talk to people about masks right now, you're likely to get a variety of opinions. Social media is exploding, you're violating my rights by making me wear a mask. And then you've got the other people saying, but I'm protecting my family and you by wearing a mask. So a lot has been written, said, and done about masks. But I guess the main couple pieces that I can leave you with is the CDC website has a really good link to information if you're thinking about bringing people back and you want them to wear masks. Okay, so social distancing is the best thing that you can do, but to the degree that you're going to have your workforce wear masks, take a little bit of time to educate them. Okay, so if I wear this scarf and I put it right here, and I say, that's my mask, that's not helping anybody. It won't help somebody because I can't talk, but you see what I'm saying. Yeah. So you got to teach your employees how to wear them, what the expectations are. It should be a snug fit. It should be secured. It has to be multiple layers of fabric. It's got to be breathable because if they're wearing them all day, if you're wearing disposables, make sure they know how, to dispose them, launder them if they're cloth. And how to remove them. When they remove the mask, make sure that, just to remind people, I'm a face toucher. I never realized until now how many times a day I actually touch my face. So make sure that when they remove the mask, they don't touch their eyes and their mouth and their nose, right? So even though those sound so very basic, ultimately we're all human. And I find, myself taking my mask off and letting it hang. Okay. Well, that's not good practice. So it's a little bit of education, and the CDC website has some posters that you can put up in your workplace. And again, even the basic hand washing posters and everything we've heard a million times, do your due diligence as an employer and just post those things, reiterate them, have a 5-minute team meeting and say, hey, tell me any tips you've had about wearing your mask and your glasses not fogging up. Just those little things to keep employees engaged, because it does get routine and somewhat mundane after a while.
Great. Well, thank you for that, Pam. And I'll remind everyone that we have another one of these webinars coming up next week. I think it's next Tuesday, or the 12th, on sanitizing your workspace. So we'll have an expert in that arena talking to us about how to properly sanitize and protect your workspace.
Susan, may I just add one thing to that on the masks?
Yeah.
So everybody has heard about the requirement from this PA Secretary of Health that we need to wear these masks. Not quite everybody has heard of the FAQs that were released a few days later. I think it would have been April 20th. The FAQs were regarding masks and other things, but a lot of it was about masks, are very helpful. For example, they indicate that if a person has a disability like claustrophobia, it would have to be demonstrated that they do, but they wouldn't have to wear a mask, and which again, the viewers might have mixed feelings about that, maybe they like masks being on other people. I'm not trying to get into that argument, but also that plastic face shields are substitutes for masks. And again, a microbiologist could more effectively state the relative, or describe the relative effectiveness of various things. I'm not pretending to be one. But if people have not read, and you don't need one in your own office, for example, you don't need a mask in your own office. If you want to wear one, good for you. But there are all kinds of, there are a lot of clarifying points in that FAQ that was again issued around April 20th. If you haven't read that, I really strongly recommend that someone do so.
Wonderful. That's great. We have really hit, I think, all of the questions that we had pre-prepared for. I don't see anything in the chat yet, but I would welcome anyone to still add with just a couple minutes left. I'm going to go ahead and put on the screen here just some reminders that we do have more of these sessions planned. Registrations are on our website. We're recording each of these sessions, and so you can go back and listen again to Pam and Mark's comments and see if there's anything there that you want to review. And we'll also update our website with many of the resources. Thank you for all of the different resources that you mentioned, Pam and Mark, today. We'll put those up as well. Remind you that we're not giving you the advice today as legal advice, but as good guidance for, for your navigating your way through this. I'll invite anyone to give me a call, an email, a text here at the chamber if there are other things you'd like us to address in future sessions. And I did mention right at the beginning, before we got started, that I wanted to ask Mark one other question. I'm not sure if he can answer, but I'll give it to you. I've heard you do some presentations on the PPP, forgiveness, EIDL, and I had a member call yesterday and ask, they had gotten the information from their bank about qualifying for forgiveness of PPP. And we all kind of, I think most of us that have delved into that know the basics. 75% of your loan needs to be spent on payroll to be forgiven. The other 25% on utilities, mortgage interest, and or lease. So this member got the information from the bank, and in reading it became very, very intimidated because it, among other things, dedicated a lot of space to the safe harbor law or rule, that if you did not use it in the right way, that you could return the money before May 7th and not be prosecuted for misuse, implying that there's, a real threat that some businesses may be misusing the funds. Have you heard anything about that? Do you have any cautionary notes for for our small businesses? I can tell you that from everything this small business told me, they were the perfect candidate. Never laid off an employee, have definitely had a big reduction in their services being used, are going to be hit hard. But they're just so afraid of misuse and then getting themselves in trouble.
Well, the forgivability decisions are going to be made by the lenders. And I listened to your broadcast a week ago today, and you had a banking person on there. I do think it is important that you get the forms that will be used to evaluate your PPP forgivability as soon as possible, because that's the bullseye that you're shooting for. As far as, have I run into sort of a sensitivity about, hey, should I have gotten one in the first place? Am I using it appropriately? I'm sure there is a lot of trepidation about that out there. It's not percolated up. I do see with any federal program, it sounds something like stand up and vote against this if you don't want to help people, and then so these things pass, and then they start to count the billions and trillions, and then they look to somebody like the IRS, and they say, well, figure out how this will work in a way that it doesn't get abused. So for example, we see FAQ 44 of the IRS guidance. The IRS has guidance regarding how to get your tax credit. Again, if this would be one of the points that I'm just going to squeeze this one in.
Sure.
For FFCRA leave, if you give leave when you're supposed to give leave, it's wonderful. It's your legal obligation. But if you don't document it correctly, you're not going to have the tax credit sustained. We're giving away all this money, these billions and trillions of dollars to people. Great. But you're counting on getting a tax credit for that, which will be invalidated a year and a half from now when the IRS comes in and audits you and you don't have every T crossed and every I dotted. And these programs are going to be the most abused federal programs you could ever imagine. Business owners are going to be giving things to their kids and so forth and so on. And I'm not saying regular upstanding folks that would participate in something like this, but they're going to be abuses all over the place, and the IRS is going to come in loaded for bear, if you will. So that's a kind of again, an over answer perhaps, but no, I am not seeing any misgivings about people saying, gee, maybe I should give this money back, regretting that they got the money. I'm not seeing any of that. I mean, a little bit of stress as the documents like the one you just mentioned seem to be more and more teethy, but I'm taking them as just kind of trying to bluff out any frauds that might be out there or to discourage fraud. But I don't think they're cutting into the into the muscle or the bone, if you will. My people are not backing out of it.
Great, that's good to hear. As a representative for small business, I think these can be really lifelines for many of our small businesses, and I would really hesitate to see a small business that this will keep in business and keep, moving in the right direction. It's someone that wants to invest in their business. I think that's exactly who this is meant for, and would love to be able to at least counsel them in that direction. But perhaps they should check with an attorney as well. So, well, thank you again, Pam and Mark. Let me just put up your contact information quickly here, and this will be part of the recording. So both Mark and Pam have suggested that, if someone needs to reach out to them, you are welcome to. Their contact information is here. And again, I'll say what I said at the beginning, that there has been such generosity of our professionals in helping us out with these kind of informational events. So I hope you all remember how important our attorneys and our HR professionals, our accountants, and all of these people are, and be willing to invest in them as you can going forward. So again, thank you on behalf of the Venango Area Chamber of Commerce, and I invite you all to back on Thursday for our meeting with Senator Hutchison. So thank you. Have a great day. Oh, yep.
Thank you for organizing this. This is well received, I believe. So thank you.
Thanks so much, Pam. Thanks, Mark.
Okay, thank you.
Bye-bye.